Yeah, yes, I give the permission.
Thank you so much. Esteemed guests, respected participants, and dear members of the audience, it gives me immense pleasure to stand before you today as we come together to celebrate the spirit of dialogue, critical thinking, and the power of words. At this much anticipated debate competition, proudly organized by the Uttar Pradesh Legal Rights Consortium, I, Adrika, the state president of UPLRC, have the distinct honor of serving as a host for the duration of this competition. Today, voices will rise not only in conflict, but in conviction. Ideas will clash, but with grace and intellect. And through their healthy exchange, we aim not only to challenge each other, but to grow together. This event is not just a test of articulation, it is a celebration of perspectives where passion meets logic, where courage meets clarity. Before we begin today's competition, I would like to invite each one of you to pause with us, not just in silence, but in solidarity. As many of you may know, our nation was recently shaken by the heartbreaking and seamless attack in Pahalgam, where innocent lives were lost to violence that words can scarcely capture. These were lives full of dreams, stories, and quiet routines cut short far too soon. In memory of those precious souls and in support of their grieving families, I request everyone to rise and join us in observing 2 minutes of heartfelt silence. Let this silence speak the words of our hearts that cannot utter, of mourning, of remembrance, and of unbroken hope for peace and humanity. Thank you. Uttar Pradesh Legal Rights Consortium, operating under the aegis of National Legal Rights Consortium and the esteemed Women's Indian Chamber of Commerce and Industry, stands as a dedicated advocate for legal awareness, empowerment, and justice, particularly for women and marginalized communities. We are committed to bringing the divide between legal principles and tangible justice by ensuring legal rights are accessible, actionable, and effectively enforced. Our initiatives encompass widespread legal literacy programs in various institutions. We also leverage online platforms to broaden our reach and foster crucial dialogues, recognizing the power of active engagement. UPLRC organizes interactive events like debate competitions to cultivate critical thinking and legal acumen, striving to build a society where legal rights are understood, exercised, and defended. At our core, UPLRC brings that informed citizens are empowered citizens, and we are dedicated to fostering a just, equitable legal environment for all. Guiding us through the intricacies of today's debate are two distinguished guests. Firstly, we have Ms. Akanksha Anand, a seasoned legal professional currently serving as in-house IP counsel at Integrated Global Services. With over 4 years of focused experience in intellectual property, Ms. Akanksha brings a wealth of knowledge in trademark prosecution, IP litigation strategy, and brand protection across diverse jurisdictions. Her expertise extends to corporate transactions, regulatory compliance, and fintech advisory. At alumna of the Indian Legal Institute and GSIPU, Ms. Akanksha is also a dedicated writer and researcher contributing to prominent platforms and actively engaging in legal scholarship. Joining her is Miss Isheta Boruah, a legal expert specializing in intellectual property rights with a strong academic foundation and a global perspective. Miss Ishita holds a LL.M. in intellectual property law and Queen Mary University, London. Graduating with merit and achieving high merit in key areas of global IP law and commercialization of IP, key areas of I'm sorry, her research delved into the fascinating intersection of IP rights and blockchain technology. Ms. Ishita also graduated with first class honors in her BA LLB honors from the National Law University and Judicial Academy, Assam, with a specialization in intellectual property rights, cyber law, and business law. Currently, she serves as an online brand protection analyst at Corsearch, Mumbai, managing online IP enforcement strategies for leading global corporations. Today, our participants will grapple with the profound, reflect, and increasing complex question. Authorship in the age of AI. Should AI hold copyright? The teams competing in the round are TC06 arguing for the motion and TC01 arguing against the motion. The esteemed panel of judges is respectfully requested to deliberate and identify the best speaker for this round of debate competition. Your expert assessment and recognizing and highlighting exceptional articulation, persuasive arguments, and insightful delivery will be greatly appreciated in acknowledging the outstanding talent among our participants. This debate will unfold under a structured format, allowing each team a total of 10 minutes to articulate their arguments. The format for the same is as follows. First, the opening arguments will be made by the team for the motion. Then, the opening arguments made by the team against the motion, followed by a rebuttal by the team for the motion, and then a rebuttal by the team against the motion. Then we'll have the closing arguments by the team for the motion, followed by the closing arguments by the team against the motion. The teams are requested to strictly adhere to the time limit specified. We will with both the teams. We wish both the teams very all the best for this round. We shall now begin. I request TC06 to kindly start once I have started. Thank you.
Okay, ma'am. Mm. Ma'am, is the timer started because it's not visible on my
No, I will present my screen. You will know when the timer starts. Just give me 2 minutes. I apologize for the
Yes,
delay.
ma'am. Yes, ma'am.
Kindly let me know if my screen is visible.
Yes, it is.
Thank you.
Yes,
The
ma'am, it is.
timer, which is On the left side is for the TC06, and the timer in the right side is for TC0. TC06, you may start.
Thank you, ma'am, for giving me this opportunity. Good afternoon, honorable judges, esteemed opponents, and valued audience members. I am Sakshi Vakmade, honored to do the opening in this debate. Today, along with my teammate, we argue in favor of allowing AI to hold copyright. Not because AI is advanced, but because it is time for our legal system to recognize the new reforms of creativity emerging in the age of intelligent machines. Let's be clear. AI systems like ChatGPT, DALL-E, and Midjourney are no longer just tools; they are co-creators. These systems can produce original stories, music, art, and even new inventions without directly copying any single existing work. Their outputs are often unique, useful, and impactful, just like works by humans. So the question we must ask is something if something is original and creative, shouldn't it be protected regardless of who or what created it? Our current copyright system was built in a time when only humans could create, but now AI can generate thousands of high quality works in seconds. If we deny a copyright simply because the creator is a machine, we leave those works unprotected, vulnerable to theft, misuse, and exploitation. That's bad for creators, companies, and innovation. Giving copyright to AI doesn't mean AI has right like a person. It simply means we recognize the value of its output. We can still assign that copyright to the developer, the owner of the AI, or even the user. What matters is protecting the output, not debating whether AI has emotions or feelings. And the current approach is already failing. In the case of graphic novel Zarya of the Dawn in the US Copyright Office, which refused to give full protection because AI had generated the comic book's novel images, even though a human spent hours guiding the process. This was still the case. This shows a legal gap. Human input is undervalued and AI output is not protected. That leaves both creators and businesses at risk. In the past, we adapted our laws to new tools like photography and film. It's time to adapt again. Moreover, copyright law has evolved before. When photography was invented, many argued it wasn't an art. Yet, courts like in case of Burov Gill's lithography company versus Saroni in 1884 recognized that the photographer's intent and creative control mattered, even if a machine took the picture. Today, a human's interaction with AI deserves the same recognition. To be clear, AI doesn't need to own anything. The copyright can still go to the developer, the owner, or the user, just like it would go to corporation or a commission work. But to refuse AI altogether because it is a machine involved is reject the reality of modern authorship. In conclusion, I would like to say protecting AI generated works, though copyright is not about giving machines rights, it's about ensuring that human guided creativity in the age of AI is respected, rewarded, and legally secured. Thank you.
I request TC01 member to begin.
May I begin, ma'am? Ma'am, shall I begin?
Yes, you may begin.
Okay. Good afternoon to the judges, organizing committee, my fellow competitors, and other audience. Today, we, today, me, Bhargavi Sugumar, and my teammate Brinda stand before you to strongly oppose the motion that AI should hold copyright. I would like to begin my arguments with the words of Justice G.R. Raghuram, former chairperson, said, I quote, If machines start creating without human intervention, the very foundation of our IP laws, which are built around human creativity and integrity, is shaken. In this tone, we'd like to place our arguments. First of all, artificial intelligence has been integrated into almost every field, say for the matter health, education, medicine, and whatnot. However, it is associated with various implications. One of such implication is granting it intellectual property rights. The first key factor to deny that AI should hold copyright is lack of originality. As we all know, Section 13 of the Copyright Act protects works which are original literary, artistic, dramatic, musical works, cinematographic films, and sound recordings. When it comes to AI generated images or artistic work, AI, which is nothing but a language learning models, and they are being trained based on data sets which are nothing but the already existing original works of authors. In this regard, there is this case Anderson versus Stability AI, where three artists formed the class to sue various AI generative platforms because they are using the original works of such artists for training their AI models without any permission or license. This case is still pending, and we are awaiting the judgment. However, often people claim exceptions under fair use doctrine, saying that training AI models with the existing work comes under fair use. Clearly is not, and that will be discussed by my teammate in the later part. The second factor to consider is fixation of ownership to AI. When we even let's say if we are going to grant copyright protection to AI, will be grant protection, whether it is the developer or the programmer or the human being who had given the prompt, so that there will be such loopholes, and any such lapse in fixation of ownership will eventually affect the fixation of liability in case of infringement of copyright. And every single loopholes like this will only weaken the IP protection regime. And such other implications involved is we all know copyright is associated with various economic and moral rights. The question arises whether moral rights can be attributable to an AI. Whether AI has reputation? No. These small loopholes will eventually affect the existing IP system. Now over to my teammate.
Yeah, I will continue with authorship in IA and doctrine of values. Authorship in IP are rooted in human creativity, intent, and accountability. The Berne Convention clearly defines that author as an expert person. Authorship implies the originality, creativity, and conciseness. Its qualities unique to the human being, not the AI. AI is not a person. It cannot form intent, take responsibility, or held liable. In the case of Dobbs in 2021, they say it is an AI system. It generated two invention and claimed AI as a sole inventor. It was rejected by the many countries like EU, US, UK, Australia. They say lack of human intervention in the system. No matter how AI advanced, it is just a tool, not a legal entity. Authorship is about the moral and legal rights. The moral right of attribution and integrity cannot be ascribed to an algorithm. It should be credit to the Photoshop or the artist who uses it. The same logic applied to an AI. In the doctrine of fair use, it is protects the human creativity and allowing the limited uses to others work for the purpose like criticism, parody, and transformation. When it comes to an AI, it is not fair use was not applicable to the AI because it was trained by the already existing work. This not comes to under the fair use. It is not a transformative work. Was held by in this case of Thomas Retrus versus Ross Intelligence, recent judgment court by the US court in 2023. AI had no transformative purpose. It was merely a copying. And the act of copying is not a creativity. The spark of authorship must come from a mind. AI is an invention, not an inventor. It's just a tool, not a thinker. The AI lacks intent, purpose, and contextual creating. It simply mimics the patterns. Machine can copy, but they cannot create the meaning. I conclude my open switch with the case of Thaler versus Perlmutter. In this case, held that the corporate protects the human works, not the AI works. Thank you.
We shall now begin with the rebuttal round. So TC 06, you may ask questions to on the arguments posed by TC 01. Hello, am I audible? Yes, you're audible. I'm sorry to inform we cannot hear you, TC06. Am I audible? I request the other member from TC06 to kindly proceed with the rebuttal. Members from the TC06 kindly respond.
Hello, ma'am. Actually, my teammate called. She was traveling and she was not able to, because it got disconnected. And I also was not able to hear you. Can you hear me now?
Yes, I can hear you
Hello.
now. Kindly proceed with the rebuttal.
Should I proceed with the rebuttals?
Yes, yes, kindly proceed with the rebuttal.
Okay, ma'am. Hmm. Yes, ma'am. So my first question is, as you have mentioned very rightly, that only humans can be authors, but what about corporate entities that hold copyrights? Or the corporations aren't people either. So why the double standard meaning behind the human tendencies only and the intent? And my other question is, if a person spends hours fine tuning prompts and curating AI generated content, though the intent is specifically coming from your argument that the intent uh, lies with humans only, but here the intent behind a person who is giving the prompts, then the creation is created by the AI, and the output is generated by the AI, which is guided thoroughly by a human being. Then the intent is not of AI, because machines don't have intent but the humans does, as it is rightly said by you. Then how will no protection be granted under the Copyright Act? These are my two questions.
TC01 can proceed with answering the question.
Ma'am, sorry, can you please repeat the questions? Second question.
I have asked. Okay.
Sorry, but
So
TC01 is like not audible.
Ma'am, am I audible? I asked for the questions, ma'am. Questions. One more time.
okay. So my first question is that you said only humans can be authors in your argument, but what about the corporate entities that hold copyrights? Corporations aren't people either. So why the double standard meaning behind that humans only become that? And second question is, if a person who spends hours fine tuning the prompts and curating AI generated content, shouldn't there be any protection for that content? Because you mentioned in your argument that the intent behind the creation can be created only by human beings, and I totally agree with the point that only humans have intent, not the machines. But the intent is transferred through prompts to the AI, then it is the person who is guiding the user, the entity who holds that, or the developer of that AI holds the authorship. So, isn't it the person ultimately doing the work through AI, which is easy? So, please answer these two questions, and I don't have any questions apart from this. Yeah.
Yeah, I answered the first question. You mentioned that the corporate will hold the copyright, but corporate or rights, there is a perpetual succession. They hold the perpetual succession right. In copyright, there is a fixation period was mentioned. It is an essential one to hold the copyright. Then how can be a corporate can hold the copyright? On in many laws in the countries, they not explicitly or impliedly they include the AI as an author. Only the human can be an author in this law. The in corporate, they are not a natural person. They are a person, but it has a perpetual succession. They not a fixed period to hold the copyright protection for it's made by the AI.
With regard to your second question,
Sure.
is the first question answered or you want more clarification?
TC01, I'm really sorry to interrupt. It's just that we cannot hear you.
Am I audible now, ma'am?
Yes, now you're
Yes, ma'am.
audible.
Even I was not able to hear the answers.
Once again, ma'am. Brinda, can you please answer again as you were not audible?
Yeah, okay. I am audible? No?
Yeah, TC01, you can be a bit more audible.
Yeah, okay. I am answering the first question. They ask the corporates or hold the uh, corporate protection right. In the corporates are treated as a perpetual succession. In the perpetual succession means they are unlimited and there is a no fixation in their copyright. In the essentials of copyright is a fixation period was there. In the corporate or perpetual section, they now can be the protects the copyright under the corporate itself, and the work of doctrine of higher it was used in IPR. The artificial intelligence or a not an person to put into a contract or a suit any person. So the human only the author of the corporate protection. It was deals under the many laws in countries like India, US, and UK, Europe, and many countries. And word like the Berne Convention also says that human only the author. It's a natural person and A is not a natural person. This is my answer to the first question.
Ma'am, am I allowed to do this rebuttal?
Yes, you can ask a question. It depends. You just don't have to exceed your time limit.
Yes,
Kindly keep that in mind.
yes, ma'am. As you have very rightly mentioned that people are behind the corporations, they run the corporations and perpetual and everything regarding the IPR. So my question lies in the very fact that a person giving prompts to AI is also a person. Doesn't he hold the authorship?
With regard to this point, I would like to answer, and also your second question. That we all know that there is this John Locke labor theory of property. Any labor, any fruit, every person has the right to enjoy fruit of his labor. So, giving prompt in an AI generative work is very, very minimal human intervention. Minimal to no human intervention cannot be called as giving labor, because even we know in the recent Ghibli trend, the Ghibli image trend, the artist took lots and lots of efforts to create such work. And see, I can give prompt, any layman can give prompt and generate through AI. So it cannot be equated. And also in this case, feast publication versus rural telephone services, where they defined originality as at least a modicum of creativity. Giving prompt cannot be attributed as creativity.
I hope the six had received their answers. Would you like to ask any further questions, or should we just take the rebuttal from TC1?
Ma'am, my second question was not properly answered. My
So,
second question was,
TC01, would you like to answer it again?
Ma'am, your second
ma'am,
question was,
it was not at all answered, the second question.
can you please repeat your second question? It was regarding this giving prompt and human intervention, no?
Yes, if a person spends hours turning the prompt and using his own creativity and curating AI content, should their work not be protected because the machine was involved? This was my question.
Yes, yeah, that was I said earlier. Giving prompt cannot be equated as creativity because it is a very minimal human intervention. Because the AI is developed. It's a language learning model, and it's made to manipulate to response based upon the data sets which are already in existence. So generating a image through AI models is in itself a copyright infringement, because even after the Ghibli trend, AI, ChatGPT's copyright guidelines have been improved. So in that regard, humans giving prompt is only minimal uh, human creativity and minimal human intervention. That cannot be called as creativity to be protected under copyright.
Uh, Dear opponent, in your answer itself, you said minimal creativity. Even if we measure creativity or minimal creativity, it is ultimately lies with the intent behind the human being, which is very true by nature. And thus, the copyright, even if it is a minimal author creativity, don't you think it should be with the person who has been, creating the content? And also I would like to ask how you have equated, is there any formula through which you have equated the minimal creativity to the original creativity along with prompt?
Actually, no. So we don't have any formula, but with regard to this, minimal, I didn't, sorry if I meant minimal creativity, it's just minimal human intervention, which cannot be equated to creativity. And also, yes, you said what I also agree with your point and disagree at the same time. Yes, giving prompt is some kind of it's some kind of work done by human, but that does not make the AI generated work to be protected under copyright. Because just because a human efforts is made, it cannot be made original. Yes, we know compilation is being protected, but the efforts made in compilation, it's not even equal to giving a prompt. Giving a prompt is just like searching in Google, but however it requires certain skills, it cannot be attributed to creativity from the person giving the prompt. It's mere minimal intervention which does not eligible for copyright protection.
Is there any eligibility criteria prescribed? Is there any eligibility criteria prescribed under the IPR which talks about minimal creativity cannot be considered to the giving the authorship or copyright?
uh, there is no minimal criteria, but even in the case Zarya of the Dawn, the court held that AI images were not product of human authorship, and thus they lacks originality. Only human authorship products are eligible for protection under copyright.
Dear opponent, it was very rightly said in the same case of Zaria Dawn in the US. The officer said that the partial co authorship was given because there was a human intention present behind that. So here, it is totally in my favor, the case and the argument that you have presented. So, how are you justifying that even human intervention is not creativity at all? Because there is no prescribed criteria, neither there is an formula or anything which prescribes minimal equity, which comes directly from the mind by the thinking, which is natural and not AI generated. Thus, AI is working under us.
Yeah, in that case, I also agree. See, and disagree at the same point. So giving prompt is a minimal human intervention, and it in itself cannot be eligible for copyright regime, because I back my argument with this 161st Parliamentary Standing Committee report on reviewing Indian IPR regime. They have suggested that they have recommended for creating a separate category of rights for AI, because they are not eligible to be protected under present copyright regime. See, giving the Copyright Act which we have was brought in the year 1957. There was not Google, AI, and everything was not present. Fitting in the present day developments into a act or legislation which has been in existence for a very long time is not right. So developing any separate kind of protection will be, for example, protecting the prompt, that will be feasible, and not fitting in it to the current copyright regime will not be appropriate.
As the society is changing, there has been increase in number of other legislations as well. Before, cinemas were also not protected, but ultimately it led to Cinematography Act of 1952. Photography was not considered as an art. Even music was not considered in the IPR. So, according to the changing technology, the legal system has to adapt. And you have quoted a judge, and I would again like to say, Dr. D.Y. Chandrachud, former Chief Justice of India, who says AI plays an important and integral role in judicial system. With the help of AI, we could advance the legal system. So I believe there is no disagreement on this part that AI will help, and ultimately the AI is a machine which works on the intention behind the human mind, which the human himself or herself thinks through the brain, which is natural and which should be given protection. Thank you. And I would not like to continue this. I just wanted to ask this and present.
Say 01, you can proceed with your
Yes, ma'am. To my opponents, you while you're arguing, you said that.
Say 01, I'm really sorry. You're again not audible.
Am I audible now, ma'am?
Yes, you're audible now.
My opponents, you told that while arguing that copyright protection can be given to the developer. Hello, am I audible?
Yes, I have
Yeah,
said.
yeah. You said that copyright protection can be given to the developer, and previously you said that the human who is giving prompt will the human who is giving prompt is also entitled to be protected. So now there is two contradictory points, whether the developer or the human giving the prompt. So, do you think that fixation of liability is an issue, and if we give AI protection to the human, obviously the artists whose work were used for training the data set will be violated. I just need a clarification on who to fix the liability.
Thank you for the question, opponent. Uh, Copyright can be given to a developer because AI is just a tool and created and controlled completely by human beings. The developer puts his efforts to build, train, and maintain the AI through his very natural mind. So they should own the rights to this output. And also, ethically, copyright should be given to the developer, and the liability can be put on the developer itself. My my teammate Ashrita would like to speak from now.
Hello, am I audible?
Yes, Ashrita.
Yeah. So I would like to say this to my fellow competitor that this is not a contradiction statement because as we see, it's already how the law works in this new regime what we are into. The issue of liability in a AI generated works is not new. Like we assign liability in many layered systems. For say, in company settings, the developer or the users who deploys the AI can be assigned the ownership and the liability altogether. Through contractual terms or legal defaults, how we work in a procedural legal field. And for say example, if a designer uses this so-called Adobe and it isn't sued, but the user is sued. Similarly, if someone uses AI to generate infringing content, the law can hold the user or developer liable, just like we already do with the software tools, autonomous vehicles or publishing platforms. So this doesn't undermine copyright. It clarifies it and it obviously gives a chain of responsibility and not confusion. Thank you.
Uh, yeah, in this regard, my competitor, you argued before that.
TC0, sorry, you're again not audible.
Ma'am, am I audible now, ma'am?
Yes.
Yes. As my competitor pointed out earlier, that a human being is using its intellect to give the prompt. He's using it. So now we are telling that the developer should be eligible. The developer does not play any role in generating that particular artistic image which you are asking for protection. So this is in itself a contradiction now. Even if it comes as a law, it is gonna create loopholes which will weaken the IP regime system.
The question
My is, but if you has exceeded that time, that I would like to ask the judges whether they would like to permit them extra time and by how much.
Yeah, I think 2 minutes would be fine as an extra time if Ishita agrees with me.
Yes, I'm with you, Akanksha.
Okay. So 2 minutes extra time to both teams. That's fine.
Thank you so much.
Uh, your answer, I would like to your question, I would like to say the supposed loop of the responsibility, I think, is an illusion and not a reality because today also ownership and liability are already well established in our legal system. And assigning AI generated works to the developer, user, or either the organization would definitely break that loop. Just like corporation, legal ownership is clearly defined through contracts and assignment. So the loophole is a mere illusion and not reality.
Uh, next question is with regard. Next question is with regard to the. Am I audible?
Yeah, yeah, now you,
Yeah.
yeah, yeah, you're audible now.
Next question is with regard to the term of protection. Generally, we consider that lifetime of author for issuing copyright protection. When it comes to developer, what will you substantiate to say with regard to the protection of term period of protection?
With regard to the term period of the protection, hello,
Yes, Ashita, yes.
with regard to term period of the protection, as you definitely mentioned that this copyright law or what we are referring to the law was obviously developed much more years and much more long years ago. The just as human authored works are granted copyright for set period, typically say 70 years from the author's death. AI generated works will follow the same standard based on the human who holds copyright, whether it's the developer, owner, or user of the AI. Basically, the purpose of the copyright term is to reward creativity and encourage innovation, regardless whether the creator is a person company, or mere AI tool. The developer or owner who is invested in the creation of this AI and the work it generates should be benefit from the same protection rights.
That was a space you know what? Do you have any other arguments? And
No, ma'am.
it's
If you'll permit me to start with my debate closing, as we conclude this debate, let us just remind ourselves that we are not standing in the past. We are standing on the edge of a creative future powered by intelligence that we humans have designed, but now that intelligence is designing on its own. AI is just no longer executing commands. It's like composing operas, illustrating books, designing logos, and even scripting films with minimal to no human intervention. But these aren't any of replication, it's original. These are their original expression and their very core creation of copyright. Basically, the purpose of copyright, when evolved as a law, was to protect originality and promote innovation. Let's not forget that. And not to merely preserve the human ego. If an AI creates something new, something valuable, and something literally original, it also deserves protection under copyright. Refusing such copyright to AI generated works does not make us defenders of creativity, it makes us gatekeepers of an outdated definition of authorship. So I ask you all, do we want to be remembered as a generation that punished innovation or rejected just an evolution? Or, or the one that expanded the boundaries of authorship and embraced the future with vision? I believe we'll choose the latter. Let's recognize AI as a creator and let's grant it copyright. As the pen is no longer just in the human hands, and that's even not a threat, that's a triumph. It's only not about giving AI human rights. It's not about equating machines with people, but it's about giving recognition to the creativity. Let's stick to it. When today AI writes screenplays, paints original arts, composes music, creates content from that of humans, these are not recycled outputs. I say these are not recycled outputs. They are original works created without human authorship. Denying copyright to AI works creates dangerous vacuum, I believe. Our laws must reflect reality, and the reality is this that AI is not coming, it's already here creating itself, and it's contributing to our betterment. Future of authorship has arrived. Let's agree on this. Thank you.
he says, it's architects.
Yes, ma'am. As we all know, the very core principle of copyright law is the recognition and protection of human creativity, which is the expression of thought, emotion, and originality that only a sentient mind can bring. Granting copyright protection to AI is associated with various risks and various legal and ethical challenges, such as accountability, intent, lack of consciousness, and everything. There is a very there is the legal responsibility. There is a very thin line between legal responsibility and ethical responsibility, because granting copyright protection to AI may cause the real works of real work of human artists to be denied, and as we recently witnessed the Ghibli trend, where the very work of the author, which takes hours and hours of work, will be denied. And it also provides a opportunity for the tech giants to establish monopolies by because AI generated work is available in minutes. So there are chances of commercial exploitation happening in the society. So the very core principle of copyright protection may be denied if AI is granted copyright protection. Thank you.
means for their arguments. I request the judges to kindly, if they have any feedback, so to kindly give the teams any feedback.
Akanksha can start if she wants.
It's okay. Okay. I'll go further and then. Okay. So it was thank you so much for having me. Thank you so much, UPLRC, for having us. And it was really nice to see both of the participants, like both of the teams are so prepared. They were great with their ideas. And obviously there was a fresh perspective. I mean, I respect TC06 for saying that they were like starting off with the point of joint authorship. And I could understand that where it is coming from because we are in the age of AI and AI is going to be like everywhere. It is now everywhere within us, in our work, everywhere in our atmosphere, everything we are going further with. And when it comes to TC0 Fund, they were very nicely prepared with it. Like they had all their arguments, whether it's committee reports, all the points which were against were marked down there. And there's one thing like I would like to say that section 2D, where nobody actually went forth and they should have started it was probably in the like I would say in the favor of TC06 because that the person who causes the works to be creative. If you see the parliamentary committee debates and the reports on it, it was actually there. It was like added to recognize that there are new generative works that are coming up and it was added back in I think 1994 if I'm not wrong, and that's where you could have built on maybe a little bit on it. But I know the both of them were quite agreeing to the fact that right now copyright act in itself lacks like a lot of things which AI needs as a protection because we cannot grant AI complete solely independent right, and we cannot have completely a human authorship with no regard to AI because AI would be very essential for development of all the countries and over the globe. So I sincerely respect all the points and I agree wherever you guys were coming from. I could see that you guys were prepared and you had your own points to put on. So it was really nice effort. All the very best for everything.
Thank you so much, ma'am, for your feedback. I would now like to request Ms. Isheta to give the feedback to the teams.
I hope I'm audible. Yeah. Okay. Thank you so much, first of all, for inviting me today. And yeah, like I heard both the sides, and you guys were like really prepared. And I agree on all the points that Akanksha has just made. Also, when TC06 was like asking TC01, like, even though there has been a human intervention whenever, like, whenever you put up prompts on AI, and then TC01 said from her side that about the division of labor, she put up that whole theory, and it was like really nice, like how she put up because that was a very fresh perspective, and I really liked that because I was thinking, okay, now how is she going to rebut TC06 the counter argument? Because yeah, like we do put up some prompts, but how will you like justify that no, like uh that it's not actually really right? So TC01 actually put up in a really nice formative way, and I really like that. So yeah, and both of the sides you are like really good in rebutting each other. So but that was one point which I really liked from TC01 when she like proposed it from her side. So yeah, kudos guys, and best of luck.
Thank you so much, ma'am, for your valuable feedback. The Uttar Pradesh Legal Rights Consortium extends its heartfelt gratitude to our esteemed judges, Ms. Akanksha and Ms. Isheta, for their generous contribution of time and unparalleled expertise and insightful perspectives to this intellectually stimulating semi-final round. Their disconcerting observations and constructive assessments not only enriched the quality of the debate, also served as a guiding light for all the participants, encouraging deeper inquiry and reflection on a subject of growing global reference. With reflection on a subject of with profound gratitude, we extend a special note of thanks to our esteemed National President, Vaishnavi Ma'am, for her visionary leadership. We also deeply appreciate the tireless dedication of Prashansa Ma'am, our National Council member and UPLRC mentor, and Khushi, our esteemed State Vice President. Our sincere thanks also to Kashish, a valuable council member, and all the committed members of UPLRC Council. Their collective efforts in conceptualizing and executing this event have been truly instrumental in making it a meaningful and impactful experience. We also take this opportunity to celebrate the commendable performance of all the participating teams. Their meticulous research and eloquent presentations and dynamic engagement with the theme reflected not only their academic rigor but also their readiness to tackle the evolving challenges of the legal world. The clarity with which they navigated complex questions at the intersection of technology, creativity, and law was truly inspiring. We believe this debate has sparkled important conversations around the future of intellectual property in AI driven era, and we are confident that such platforms will continue to shape thought through leaders and change makers of tomorrow. As we conclude this round, we look forward to witnessing the continued excellence and these brilliant minds in the grand final and beyond. Thank you.
Thank you, everyone.
Thank you so much.
Thank you, ma'am.
Thank you so much, ma'am.
Question from the Excel sheet.
Thank you, ma'am.
Yes, ma'am.
Uh, like where do we have to put up the like points? Because I think Ishita has done it. So should I just mention the points there or is it done?
No, ma'am, you can also mention your points there. We are also facing issues by we are not able to see your scores, Akanksha, ma'am. We are able to see Ishita ma'am's scores.
Yeah, yeah.
Akanksha, you can see in the below there's Judge 01 Ishita and Judge 02 Akanksha. If you can see, I think you will find it below.
All right, all right. Got it. Yeah, yeah, yeah.
Oh yeah, yeah.
Okay. Cool.
Thank you so much,
Thank you so much.
ma'am, for being here and helping us with judging this competition. We really appreciate you took out time for this.
Thank you so much for having us. It was really nice. It was really great to actually see all this. And thank you for to whole organizing committee for such a seamless experience.
Thank you
Yeah.
so much, ma'am. Thank you.
Thank you.
Hi, guys. Good evening, everyone. I welcome all the everyone here. We will start in 5 minutes as Muskan ma'am hasn't joined the meeting yet. Uh, thank you. So all the participants to kindly switch on their cameras. Kindly let me know if my screen is visible to everyone. Am I audible?
Yes, it is visible.
Thank you. Esteemed guests, respected participants, and dear members of the audience, as we convey today for this highly anticipated debate competition, a platform where ideas converge, arguments are forged, and the power of articulate expression takes center stage. It is with immense pleasure that we, the Uttar Pradesh Legal Rights Consortium, bring you the stimulating event. I, Adrika, the state president of UP-LRC, have the distinct honor of serving as your host for the duration of this competition. Before we begin today's much anticipated debate competition, as many of you may know, our nation was recently shaken by the heartbreaking and senseless attack of Pahalgam, where innocent lives were lost to violence that words can scarcely capture. These were lives full of dreams, stories, and quiet routines cut short for far too soon. In memory of those precious souls and in support of their grieving families, I request everyone to rise and join us in observing 2 minutes of heartfelt silence. Let this silence speak the words our hearts cannot utter, of mourning, of remembrance, and of unbroken hope for the present, for the peace and humanity. Thank you. The Uttar Pradesh Legal Rights Consortium, operating under the aegis of National Legal Rights Consortium and the esteemed Women's Indian Chamber of Commerce and Industry, stand as a dedicated advocate for legal awareness, empowerment, and justice, particularly for women and marginalized communities. We are committed to bringing the divide between legal principles and tangible justice by ensuring legal rights are accessible, actionable, and effectively enforced. Our initiatives encompass widespread legal literacy programs in various institutions, focusing on vital areas such as women's rights, health rights, and workplace protections. We also leverage online platforms to broaden our reach and foster crucial dialogues. Recognizing the power of active engagement, UPLRC organizes interactive events like debate competition to cultivate critical thinking and legal action, striving to build a society where legal rights are understood, exercised, and defended. At our core, UPLRC believes that informed citizens are empowered citizens, and we are dedicated to fostering a just and equitable legal environment for all. Guiding us through the intricacies of today's debate are three distinguished legal professions. Firstly, we have Ms. Muskan Rani, an advocate participating before the Honorable High Court and Supreme Court of India, specializing in intellectual property rights and technology. Ms. Rani holds a BBA LLB from Bharati Vidyapeeth, Pune, and an LLM from Jindal Global University, where she was awarded the prestigious Savitri Jindal Scholarship. With extensive experience in civil and criminal litigation, academic research, and policy writing, her work focuses on data privacy, crime, and the evolving legal dimensions of technology. As a published author and committed legal researcher, she brings a balanced and insightful perspective to her role as a judge for this semi final round. Joining her is Ms. Sukrati Gupta, an associate at a reputed IP law firm specializing in intellectual property rights with a focus on trademark law. Ms. Gupta holds a BBA LLB honors degree from NMIMS Mumbai and has been actively practicing IP law since 2021. Alongside her legal expertise, Ms. Gupta has contributed significantly to business development, having successfully onboarded several international clients and strengthened global partnership for her firm. Her work spans legal advisory, prosecution, and strategic IP portfolio management. Our third esteemed judge is Advocate Ekta, a trademark attorney and legal associate based in Pune with expertise in IPR, RERA, and property law. Advocate Ekta currently advises on corporate compliance and contract law at Citadon Private Limited and practices as a legal associate at Kothari Legal Services. She holds a LLB from Savitribai Phule Pune University and brings a strong foundation in legal research, drafting, and client advice. Today, our participants will grapple with the profound, relevant, and increasingly complex question: authorship in the age of AI. Should AI hold copyright? The teams competing in this round are TCD03 arguing for the motion and TC02 arguing against the motion. The esteemed panel of judges has respectfully requested to deliberate and identify the best speaker for this round of debate competition. Your expert assessment in recognizing and highlighting exceptional articulation, persuasive arguments, and insightful delivery will be greatly appreciated in acknowledging the outstanding talent among our participants. This debate and structural format, allowing each team a total of 10 minutes to articulate their arguments. The format for the round is as follows. First, the opening arguments will be made by the team for the motion, followed by the opening arguments made by the team against the motion. Then the rebuttal by the team for the motion, followed by the rebuttal by the team against the motion. In the end, first the closing arguments made by the team for the motion, followed by the closing arguments made by the team against the motion. The teams are requested to strictly adhere to the time limit specified. We wish both the teams the very best for this round. Uh, I will request the teams to begin once I have shared the screen of for the timer. I also request all the judges to kindly switch on their cameras. As it is visible, there are two timers. The left is for the team for the motion, and the timer in the right is for the team against the motion. Uh, I would like to request the team for the motion to kindly proceed with their opening statements.
Good evening, esteemed judges, respected opponents, and distinguished guests. Today, we TC03 stand before you to argue that in a rapidly evolving digital landscape, the time has come to recognize artificial intelligence systems as valid copyright holders for their creative works. The question that we face is not whether this change will happen, but rather how we will adapt our legal frameworks to the inevitable reality of AI authorship that already exists today. Now, what defines an author? Is it the flesh or is it the mind? Copyright Act 1957 defines author under Section 2D in relation to literary, dramatic work, musical work, artistic work, and cinematograph, film, or sound recording and a photograph as a person who causes the work to be created. Section 14 of the Act defines copyright as an exclusive right subject to the provisions of the Act. Now, before proceeding, let us clarify that what we mean by AI holding copyright. We are advocating for a legal recognition that certain advanced AI systems they can generate original creative works that are independent enough from human input to warrant their own copyright protection. This doesn't diminish human creativity, but acknowledges a new category of authorship emerging in a digital age. We stand firmly for the motion AI should hold the copyright. Now, throughout history, copyright law has adapted to emerging technologies from printing press and photography to cinema, digital art, and computer software. Now, each technological leap, it raises the same fundamental question. Does this new form of creation deserve protection? Today, with AI at the forefront, we face that question once again, not for the first time, but as a part of copyright's long and evolving journey. AI represents the next natural evolution. Now, there is this need to understand how AI works with regard to creating such subjects that are unique in nature. These are done by sufficient prompts given by the user using that AI tool. Here comes a distinction between AI assisted work and AI generated work, wherein we see that AI generated work starts by just a mere prompt given by the user and it goes on to further make a distinctive piece of literary work images based on that prompt. Now, this draws our attention to the very fact that AI too should hold a copyright since it produces something of its own out of its own creativity. Thus, we are not claiming copyright for AI assisted work but rather AI generated work. To safeguard the integrity of innovation in the digital age, AI generated work deserves copyright protection. And if the law rewards originality, it should not discriminate based on what's made of silicon, and what's made of skin. As we stand as the threshold of this new creative era, our legal framework should keep in pace with our technological reality. Now, consider this. If I create a literary work through my own original thought that's infused with creativity and uniqueness, and someone else falsely claims it's adds there, it would be a blatant violation of my rights. Why should it be any different when it comes to AI generated content? Today, individuals are profiting by claiming authorship over works solely created by AI works they never conceived nor crafted. Isn't that the height of hypocrisy? Why do we tolerate such double standards in the name of innovation? Now, it's not about replacing humans, but it's about protecting innovation. AI can coexist with human artists just like digital art did with painting. Now, for fostering innovation in a digital economy, it is essential that our legal frameworks they evolve alongside the technological advancements. Copyright law exists to incentivize creation, protect ownership, and promote progress in science and the arts. Extending copyright to AI aligns perfectly with these objects. Recognizing AI as a rights holder encourages innovation, ensures legal clarity, and sets a standard for future technological breakthroughs, thus upholding the core purpose of copyright law of fostering creativity and progress for all. An AI system called Tabis was listed as an inventor on a patent application in South Africa, and thus South Africa became the first country to grant a patent recognizing an AI as inventor. Now, this stand is a landmark moment that proves global legal systems are beginning to adapt to technological reality. Now, I'd like to raise a question that if AI can be invented in patent law, then why not an author in copyright law? And overlooked yet pressing concern demands our focus. The legal void that forms when AI generated works are denied copyright protection. The World Intellectual Property Organization, WIPO, in its discussion paper, Conversation on Intellectual Property Policy and Artificial Intelligence, it highlighted the growing role of AI in generating literary and artistic works. Scholars presented arguments advocating for the protection of AI generated work, asserting that denying such protection to the absence of human intervention, it would result in these works falling into the public domain and thus, in turn, will allow the consumers to access and use use these works without the fear of copyright infringement claims. They contended that refusing authorship to these categories of works would be detrimental because it will stifle and impede creativity. Now, thus reaffirming that denying AI copyright leads to a creation of dangerous legal vacuums. Now, as we stand at the threshold of this new creative era, let's ensure that our legal frameworks they keep pace with our technological reality, and recognizing AI copyright doesn't diminish human creativity. Instead, it acknowledges that creativity itself is evolving and a law should evolve with it. Now, thank you for your patience for hearing me. And now I would like to pass the stage to my co-counsel.
The team against the motion can proceed with their opening statements.
Good afternoon. Good afternoon to honorable judges and everyone present here. Let me first start by asking a question that if a robot writes a book on, then who is the author, the machine or the mind who built it? And if a drone takes a photo, do we credit the drone or the human who directed it? So, copyright is not about who typed the words or generated pixels. It's about who imagined it, who took a risk, and who put their identity into it. And that's why we TC02 stand against the motion that AI should not and cannot hold the copyright. First, copyright is rooted in human intent and expression. Copyright is uh, not about whoever produces content. It is about to those who create with intent. It's a recognition to effort, originality, and emotional labor. That's why courts around the world reject the copyright claim from animals or nature. So if a monkey takes a selfie, it's a viral meme, and but not it's not a legal author. So AI, no matter how advanced, it lacks the human ability to think, to feel, or to decide. It doesn't create with purpose, it executes a pattern. And it doesn't know what it made or why. It just doesn't know that even it exists. So if we give copyright to AI, then we will be redefining it not as a recognition of originality, but as a reward for computation. So creation without consciousness is output and not authorship. Secondly, now let's talk about law. That copyright is not just a medal for creativity, but it's a legal tool, and it gives the author the right to license, to sue, or to transfer ownership. But for that, the author must be a legal person. So the question is that can AI testify in court? Or can it sign a licensing agreement? Or can it be held liable if its work causes harm? No. And even if we grant the AI copyright, then who would receive it? The model, the engineer, or the company who that trained it on stolen art? So what we create, we must take responsibility for it. But AI cannot take responsibility because it cannot even comprehend that what is right and wrong. Hence, it's not a legal person. So you cannot own a right if you can't help be accountable for it. Thirdly, that AI learn from us, from the books we wrote, the art we painted, and the code we built. Its creativity is a reflection of billions of human works. And that's not innovation, that's a collage of various work. And here's the problem that much of this data is scripted without consent, meaning that AI generated content may be built on intellectual property violations. And if we grant them AI the copyright, then we will be rewarding theft and punishing the original creators whose work was absorbed without credit. So AI doesn't dream, it samples, and sampling without credit isn't authorship. Now let's talk about the consequences. Like who will benefit if AI holds copyright? It's just not the public, not the artist, and the only winners are the corporation that own these models. AI will churn out books, images, and music, flooding the market. And independent creators will be buried. Human voices will be drowned by automated content with legal protection this time. Imagine a future where every idea belongs not to an artist but to a server farm owned by a tech giant. Is that a creative future or a commercial monopoly? So we are not empowering AI here. We will be empowering corporation to mass produce creativity and just call it an art. And on the next point, we say that giving copyright to AI will legitimize output, which includes dangerous or misleading ones. Imagine an AI generating a fake news report, a deep or a plagiarized image, and that too not protected by law this time. So copyright is a form of endorsement and recognition. Assigning that to an unfiltered AI will open the door to legalize manipulation. Also, now some may also argue that but human use AI to create. Shouldn't that count? And they're right. It should, and it already does. Current copyright law supports human authorship assisted by AI. If you prompt, guide, and edit or refine, the final work can be yours. But the key is that the human must be at the center of creation. So we don't need a legal revolution here. We just need a clear boundary that a human create and AI assist. That way, the rights goes to the mind that shaped the vision and not the machine that rendered it. So we usually say that the brush doesn't own the painting, the writer does. So now let us all be clear that AI may generate, but it does not create. It may mimic, but it does not imagine. And it may assist, but it should never replace the human soul behind every stroke, word, and note. And that soul is what copyright exists to protect. Thank you.
PC03, you can proceed with the rebuttal round.
Good afternoon, one and all present here. So my friend here have given several points against the motion, and now I would like to highlight why all of these does not stand outside the fact that why AI should be given authorship, AI should be given copyright. Now the first thing that my friend here mentioned is that if a robot is writing a book, isn't it the human who have programmed it? Now it is certainly the fact that human are the one that have created it. So is the fact with cameras. It was created by human, but still we are now giving copyrights, that exclusive right to the photographs as well, isn't it? Now here I would like to quote Justice Beach from Thaler versus Commissioner of Patents case, where they have where justice have stated that we both are created and create. So why can't our own creations create further? Now there is certainly a question that if humans are programming certain things, then why should AI be given all the rights when ultimately the source, the mind is of the human? But here comes the fact that humans are creating certain kind of AI generated platform wherein AI could self learn. So here they have given just a prompt. Further work, further uniqueness, further creativity is added by AI, and which is why we like to again draw this distinction between AI assisted work and AI generated work. And we, TC03, as a team, is claiming authorship under for AI in the copyrights in context with AI generated work and not AI assisted work, which certainly have had human element into it. Now, let me pose an example for you. If I have given certain of the prompts in one of the AI generative platform where I am just giving mere words, now AI on the basis of its own research ability will go on and create something out of its own. I would also like to highlight the point that when the my friend here has mentioned AI generated work is a mere work of collage, or most um, uniquely known as a magic copy machine. It is a very drastic misconception. It is not a magic copy machine, and it does help in collaging, collecting all the sources in a way when we regard AI as an AI assisted work. But here, when we are talking about AI generated work, it uses its own self learning programming in a way to create something out of its own, to create something unique in a way that it could produce, it could have this independent thought, its own creation, and which is why it is distinct and creative in its own sense. Now, when we are saying that ultimately, even if we go on by giving copyright to the AI, it is ultimately the corporate who will be benefiting out of it. But then isn't it in a kind of de-incentivizing the corporate who are producing, who are investing so much into this particular programming in order to further them, when we are denying a work? So the example which was put forth by my co-counsel, that wherein when I have created certain work but someone else claim it, now when on the other spectrum it's AI, why are we denying that right?
Yes.
I have a question. We proceed further. I have question from T3, sorry, TC03. So when you say that AI generated work, so what do you mean by that? Can you please explain it with example, practical example?
Sure, ma'am. So there were certain of the case studies which has been conducted and have come put forth. So there was this one I'll give two examples. There was this one Canadian person who has applied for under CIPO, the Canadian Intellectual Property Office. Now he has created an artistic work with regard to by using certain of the generative AI platform. He wanted to claim copyright for the same. Now the authority did not have any um so the forms that he was likely to apply for was where he was supposed to mention the name of the author, the address, and other contact details, and so on and so forth, which is why our authority in that sense are not accommodating AI. Now here he himself has claimed on one of the so he claimed the copyright for that artistic work under his own name, but further on he came clean on some on one of the social media platform by claiming that the entire work has been created had been generated by AI, where he had just given certain of the prompts. So now when I have a document with me in place, and when I'm giving it to a generative AI platform, and when on the basis of that, if I ask that AI platform to produce a research paper maybe, so I am just merely feeding AI for that sort. And now the entire work is done by the AI. The second example that I would like to give is of Zaira, the Dawn. So that this was again one of the book which was made. This was the case in US. Here, this was a comic book wherein the text was made by the author. So it was written by the author, but the images were AI generated. Now in that particular circumstances, the copyright authority of US, they allowed the textual thing which had the human element into it, but they did not allow the images which were created by AI. So these were the two instances where the author per se have no role in the image that was created, and that was so entirely AI generated, and which is why USA partially allowed the Zara of the Dawn publication, wherein the textual thing were allowed. However, the artistic work, the images, they were not allowed.
Okay, thank you.
Please say the with your department.
Good afternoon, honorable judges and respected opponents. We stand here against the motion on the present issue that whether artificial intelligence should be granted copyright. We highly appreciate the contentions which have been put forth by the opposing counsel, but upon crucial and closer examination of those contentions, we are raised with some serious flaws. Firstly, answering the contentions which have been put forth by the opposition is that giving artificial intelligence the copyright encourages innovations and inventions. But this statement is not true in its eternity because innovation comes from human beings who uses artificial intelligence but not from the artificial intelligence itself. If we want to reward innovation, let us reward the programmers, designers, and users who have guided the system and not the machine that mechanically executes the command. Respected judges, the whole purpose of the copyright law is to grant the protection to the original creators of that work so that there is no kind of infringement, a moral infringement of those works. But in the present case, we are dealing with granting copyright to a technology which is artificial intelligence. I would like to present a case among you all, the case of DABUS software, which was created by a English programmer, which is named as Device for Autonomous Bootstrapping and of Unified Sentence, which is basically a software for invention. The creator of the software has has claimed copyright over this invention, but the United Kingdom's Court of Appeal has laid down that we should stick with what is law and what we should stick with what is law, but not what the law ought to be. He said clearly in his judgment that the whole purpose of the copyright law is to grant protection to the human expression and the meaning, the innovation or the intention behind claiming that work. But since AI generates the work on its own, we cannot grant a whole copyright or the legal ownership over that. Secondly, originality requirement. The work which is created by artificial intelligence is not met. Respected judges, copyright law is not all about originality or novelty, but it's also about creative expression and an independent expression which artificial intelligence fails to generate, because that is merely a technology, a machine that is being worked on certain human commands and the data which has been fed into it. But the moment that data has been removed from that particular technology, the machine fails to generate something on its own. So it would be a very difficult situation where we are talking about granting copyright to the artificial intelligence. Thank you.
If there are any other rebuttals that DC03 would like to make, please, you can proceed with the same.
For the rebuttals or the conclusion?
Sorry, please could you repeat?
Uh, when we can make
Uh, you have a rebuttal?
Yeah, like there are certain of the points still remaining, or should we just proceed with the conclusion?
If you have rebuttal, you can make, but please be mindful of the time.
Well, then I'll proceed with the conclusion itself.
Okay, you can ask the judges as well once if you would like extra time. That is also
I would
an
like to listen them if time permits.
Yes, yes, me too. Please carry on.
some judges. Would you, how much extra time would you like to permit both the teams for the same?
2 minutes each? Yes, I think 2 minutes each will work.
Yeah.
Okay. Okay. Thank you. TC03, you can proceed with the rebuttal.
Now, when the cases have been cited, authorities have been mentioned, I would like to mention a point that authorities need not to relax their standards. So, when a point has been made that if we allow AI generated work and give copyright to them, then what about the deepfakes? What about the plagiarized work? Now, the same thing could happen with human as well. It is no wonder that human, when we go out to research, we too tend to fall under this particular pretext, and when we do plagiarize work. Now what we are here claiming is not for the authorities to relax the standards for giving copyrights, which in itself is a very difficult task to get, but it is also in order to expand, just not just remain it to human, but then also to expand the spectrum to even include AI work. Now why are we claiming this too? It have an economic aspect related to it as well. The point which I had further initially made about the incentivizing. Now, when AI would not be given due credit for the work that it's doing, and some other human, just by the virtue of being human and a user of that particular AI platform, gains profit out of it, isn't it just a blatant violation of the copyright regime, and in the purpose for which this copyright and IPR laws exist in this era is to give exclusive right over the works that has been created, that has been generated. So why are we discriminating whether it is a human or it is an AI generated platform, wherein what we all must seek to focus on is to meet the purpose to grant all the exclusive rights over the creativity over the generative platform that AI is also working towards.
TC03, we like to rebut the points that are made by these.
Yes, we also had certain points. Respected judges, we live in a highly competitive society where the levels of technology and creativity are increasing day by day. Now, if we were to grant copyright to artificial intelligence and recognize it as an independent author, human authorship gets devalued. Now, in an AI dominated content economy, artists, writers, and musicians will find it difficult to compete with the levels of the content which would be generated by artificial intelligence, not just economically but culturally as well. We risk reducing art to algorithmic output, undermining the richness of human emotion, which would ultimately lead us to dilution of human creativity. Secondly, if we were to grant copyright to artificial intelligence, we risk the opening doors to machines to hold other rights as well: property, patents, even legal personhood. Now, this would blur the thin line between humans and machine, which could be exploited by the powerful interests to avoid accountability and bypass the labor protections as well. So, let us not defeat the whole purpose of the copyright law, which is to grant the protection to the human work which has been created. And one of the question that I would like to ask the opposing counsel is that if AI is granted copyright, who becomes legally responsible for any misuse or infringement? Is it the artificial intelligence itself, or is it the developer? If we were to grant an independent authorship to artificial intelligence.
I would like to ask the judges whether they would want to proceed with these three selected questions asked by these three.
Yes.
Thank you. Casey Iruji, you may proceed to answer the questions by these.
Accountability certainly is one of the major issue which we face in today's era due to AI. Now that is what we would like to portray. We would like to highlight as a team when we are speaking in for the motion for giving authorship to AI under copyright law. It's because it is the lack of exploration when we are certainly closing the doors for AI to even get any kind of recognition in certain works which are altogether claimed by humans in itself. But when we are claiming that copyright should be granted to AI, what we here like to highlight the point is that it would, on contrary, would increase transparency. Now, the example that I have stated, if in any case those copyright of the Canadian man who has published his artistic work, the entire accountability would certainly fall within the fall on that Canadian man itself. But there are certain of the instances wherein people are using human are using highly using the AI generated platform, and it is something which poses a threat to the creativity and all the things that we are claiming right now. Hence, what we here claim is to have an incorporated spectrum in a way that authorities are expanding their recognition of AI authorship, not just restricted to humans, but are expanding their spectrum to even include AI work in order to have more accountability. Because when we do not have that regime altogether, how would we then have certain this idea of transparency and accountability? Hence, what we are claiming as a team is to have this open understanding, have this liberal understanding in a way to even include AI under IPR laws.
Casey, would you have any rebuttals by the arguments asked by these?
No.
Okay, then I would like to yes, ma'am.
I have a question from T02, TC02. When you have given a wonderful speech on the same, but do you have any landmark judgment which you would like to support with for your argument? It can be from anywhere in the world.
Respected judge, as I have already stated about the landmark judgment of the DABUS case,
No, any other than that.
ma'am, as of now, we have only read about that case. We are not really aware of any other judgment.
All okay.
Thank you, ma'am. I would now like to request TC03 to kindly proceed with their closing arguments. But before that, I would like to request the judges if they would like to give them extra time for the closing arguments, as TC03 has run out of time.
How many, how much time are they allotted for the conclusion part?
2 minutes.
Uh, Miss Muskan, I think it's fine for me. Yeah, we can, no, we can go with 1.5 minute.
Yes,
Like,
we
it's
can
not
do that.
good. Yeah.
Okay. Thank you so much. TC03, kindly wait until I set the timer. TC03, you may start.
When we are certainly claimed for the fact that AI should be given copyright, there then comes the question that how can we even have its implementation in place? What are the situation in which we could actually have the authorship for AI be applied in different situations? So here we would like to portray two situations wherein AI could be given copyright. One is in a situation where AI is the sole author in the cases where user have made only de minimis contribution to the output's expression. So the examples that I've just stated about the Canadian man at the Zara of the Dawn, and also there was one more case in the Chinese court, that is Li versus Liu, wherein the court, even though have ruled, so the facts were similar as the Zara of the Dawn. There was this one picture which was entirely AI generated. However, the Chinese court, and since the text was made by the author itself, the Chinese court have held in favor of the author by giving the copyright. However, they have claimed that there should be an incorporative guidelines in order to have AI in this copyright regime. Hence, they have shown their acceptance of AI in copyright regime as well, where AI should be regarded as the sole author. The second is one of the most plausible way that we could actually begin with in today's time. That is where user and AI must be regarded as a joint authors, where both's contribution to the expression is in a collaborative fashion and both could be realized. So in this, it appears to be the most plausible solution to this problem, wherein both the user and the AI are given due recognition for their work. Thank you.
I would now like to request TC02 to kindly proceed with their closing arguments.
Respected judges and worthy opponents, as we approach the conclusion of this important discussion on whether artificial intelligence should hold copyright, we stand firmly against the motion. We are at crossroads where law, creativity intersect with each other, and we are dealing with the same relationship in the present issue. Copyright at its core is not just a legal label. It is a recognition of human creativity, human labor, and human invention. It protects the expression of ideas, not the mechanical reproduction of those ideas. Artificial intelligence, no matter how sophisticated, is not capable of thinking on its own, but also it does not feel, create with purpose or passion, but simply processes. It generates on the patterns found in the human work, which is not in actuality be termed as innovation. The proposition has argued about artificial intelligence producing original works, but originality under copyright law is not just about novelty, it is about independent and creative expression. Machines do not have that. Their outputs are derivative and they are trained on human made data. But once that data has been removed away, the machine has nothing to say on its own. This is not a question of technology we are dealing in the present issue, but instead it is a question of principle. By granting the copyright to artificial intelligence, we risk diluting the meaning of creativity itself. We replace artistic intention with algorithmic output. Lastly, I would like to say that let me leave you all here with a simple analogy that a paintbrush can produce beautiful works, but we never credit the brush. Similarly, artificial intelligence is a powerful brush indeed, a strongest one we have ever made, but it is still a tool which is intelligent enough but it cannot be inspired. So let's not rewrite the rules of authorship to accommodate machines, but let us reaffirm our commitment to human mind, human heart, and unique ability of human to create with meaning. Thank you.
Thank you to both the teams for their arguments. I would now like to request the judges to, if they have any feedback to be given to the teams, kindly proceed with the feedback. Yes, ma'am.
So good afternoon, everybody. And first of all, thank you for inviting me. And firstly, I would like to commend both the teams. Both of the teams were very good. TC02 and TC03. And the discussions were very thoughtful, very engaging debate. All the rebuttals were very good. All the arguments were very good. So I'll give the feedback by team to team. So team TC03 of for the motion, they presented strong arguments, especially by drawing on relevant precedents and the examples. You highlighted how AI can produce original content and suggested legal recognition, even if it's indirect in the IP law. Your argument about assigning copyright to developers or companies, uh, it was very insightful. Coming on to team TC02, which was against the motion, you got a very, very valid and significant concerns, which particularly regarding the authorship, accountability, and the purpose of the copyright. You rightly question that if the AI is granted copyright, then who is the author? Who is accountable? And these are very crucial legal questions. You emphasize that AI is not a tool. You said that human create an AI assist, and AI should be used for assistance, not for taking the credit away from the humans. I appreciated both the team's arguments. One feedback which I have is that both of the teams could have given more case laws, examples, and the daily day-to-day life. It's filled with AI. You could have given a lot of examples. The Ghiblification trend is there. Everybody knows about the Ghibli thing. You could have used that, whether it is good for the humans or not, because there are assertions that the data we feed on the AI, it's not whether it's whether they are stealing the data or not. There are a lot of debates revolving that. So I think you could have taken those points as well. Otherwise, both the teams were very good. All the arguments were very good, and all the best for your future.
Thank you, ma'am. Um, Anna, could you please proceed with your feedback?
Yes, actually, I think Miss Gupta has already explained the team everything. I don't think there's not anything remaining. But I'm also learning. I am also learning. I am also into this field. Even recently, I have written a paper on AI. So whenever it is a debating topic, and it's a never ending. So I will not say n number, but at least I have in favor in the for the motion I have 10 case laws, and against the motion also I have 10 case laws. Okay, which I feel which was lacking as already Ms. Gupta has stated that definitely when we come for a debate, we must be prepared for each and any questions come from the judges or from the parties or like from opponent, because and otherwise it was good. You guys spoke well, both the team. I'll not particularly go from one to one, but you spoke well. But I felt that I will not take the team names, but I felt the AI was used for your speeches as well. So that is what I felt. But otherwise, it was good. But going forward, I would suggest, the mere suggestion from my side is that, going forward for anything, uh, more of precedence will be helpful for you. That's all.
Thank you, ma'am. I would now like to request Advocate Ekta to kindly proceed with her feedback. Ma'am, I think you were not audible because I could not hear you.
I think
Ma'am,
someone should contact her because she's not able to, I believe.
yes, ma'am, you're not audible. You're not audible yet. Thank you, ma'am. Ma'am, if you like, you could give the feedback in the chat as well. Uh, by the time ma'am writes. Okay. Thank you, ma'am. The Uttar Pradesh Legal Rights Consortium extends its heartfelt gratitude to our esteemed judges, Ms. Muskan, Ms. Sukrati, and Advocate Ekta, for their generous contribution of time, unparalleled expertise, and insightful perspectives to this intellectually stimulating semi final round. Their disconcerting observations and constructive assessments not only enriched the quality of the debate, but also served as a guiding light for all participants, encouraging deeper inquiry and reflection on a subject of growing global relevance. With profound gratitude, we extend a special note of thanks to our esteemed National President, Vaishnavi Ma'am, and for her visionary leadership. We also deeply appreciate the tireless dedication of Prashansa Ma'am, a National Council member and UPLRC mentor, and Khushi, our esteemed State Vice President. Our sincere thanks also to Kashish, a valuable council member, and all the committed members of UPLRC Council. Their collective efforts in conceptualizing and executing this event have been truly instrumental in making it a meaningful and impactful experience. We also take this opportunity to celebrate the commendable performance of all participating teams. Their meticulous research and eloquent presentations and dynamic engagement with the theme reflected not only their academic rigor but also their readiness to tackle the evolving challenges of the legal world. The clarity with which they navigated complex questions at the intersection of technology, creativity, and law was truly inspiring. We believe this debate has sparked important conversations around the future of intellectual property in an AI-driven era And we are confident that such platforms will continue to shape through leaders and change makers of tomorrow. As we conclude this round, we look forward to witnessing the continued excellence of these brilliant minds in the grand finale and beyond. Thank you. I would like to request the participants to kindly leave the meeting. I would like to bring to all the judges' attention that kindly put the scores. We are not able to see the scores that you have put as of now.
I have shared. I
Okay.
Please check. So should I send it by email, the Excel sheet, or should I do it in a Google Sheets?
Ma'am, actually the sheet is live, so we can see the scores. So you can just put your scores there, and we will be able to access it.
Sure. Just give me 2 minutes, I'll do it.
Sure, sure. Ma'am, you're also free to leave the meeting and then do the scoring also. We have another round as well to proceed with.
Sure, sure, sure.
Thank you.
Thank you so much for the opportunity. It was glad. I
Thank,
was
thank you so much to all the judges for taking out their valuable time for judging this competition. We really appreciate your time and your feedback. Thank you so much. Good evening, everyone. We will start with the round shortly, as one of the teams, TC05, hasn't joined yet. Uh, Once they have joined, we can start. I request all the participants and judges to kindly switch on their cameras. I would like to seek permission from the judges for starting the competition.
So,
Thank you. Is my screen visible?
Yes, it is.
Esteemed guests and respected participants and dear members of audience, it is a privilege to address you at the commencement of this significant debate competition, an initiative proudly presented by the Uttar Pradesh Legal Rights Consortium. Today, we gather to champion the values of thoughtful discourse, sharp intellectual engagement, and the compelling force of well-reasoned arguments. I, Adrika, the state president of UPLRC, have the distinct honor of serving as your host for the duration of this competition. As many of you may know, our nation was recently shaken by the heartbreaking and seamless attack at Pahalgam, where innocent lives were lost to violence that words cannot scarcely capture. These were lives full of dreams, stories, and quiet routines cut short far too soon. In memory of those precious souls and in support of their grieving families, I request everyone to rise and join us in observing 2 minutes of heartfelt silence. Let the silence speak the words of our hearts that cannot utter, of mourning, of remembrance, and of unbroken hope for peace and humanity. Thank you. The Uttar Pradesh Legal Rights Consortium, operating under the aegis of National Legal Rights Consortium and the esteemed Women's Indian Chamber of Commerce and Industry, stands as a dedicated advocate for legal awareness, empowerment, and justice, particularly for women and marginalized communities. We are committed to bringing the divide between legal principles and tangible justice by ensuring legal rights are accessible, actionable, and effectively enforced. Our initiatives encompass widespread legal literacy programs in various institutions, focusing on vital areas such as women's rights, health rights, and workplace protection. We also leverage online platforms to broaden our reach and foster crucial dialogues. Recognizing the power of active engagement, UPLRC organizes interactive events like debate competition to cultivate critical thinking and legal acumen, striving to build a society where legal rights are understood, exercised, and defended. At our core, UPLRC believes that informed citizens are empowered citizens, and we are dedicated to fostering a just and equitable legal environment for all. Guiding us through the intricacies of for today's debate are three accomplished legal professionals. Firstly, we have Advocate Kalyani Munde, a practicing advocate based in Pune with expertise in both litigation and non-litigation matters. An alumna of ILS Law College, Pune, she also holds an LL.M in intellectual property rights and technology from OP Jindal Global University, where her research focused on the role of IPR in protecting content creators. Her academic and professional background brings valuable insights to this semi-final round on artificial intelligence and IPR. Joining her is Advocate Divya Jain, a dynamic legal professional with a strong academic background and diverse practical experience. A top ranking graduate of MGM Law College, she is currently pursuing her LL.M in Constitutional Law at Government Law College, Mumbai. Her qualifications also include diploma in pharmacy, cyber law, and intellectual property rights. With expertise in IPR, dispute resolution, and law and medicine, she has significant experience in patent law and mediation, including work with the online Lok Adalat Sama in collaboration with the World Bank. Our third esteemed judge is Advocate Aishwarya, a lawyer from Kerala who completed her unitary LLB from His Highness Maharaj Government Law College, uh, Irankulam, Kochi. With a prior degree in computer application, she combines her legal expertise with a strong tech background, currently pursuing a master's with a focus on criminal justice administration. Her academic interests also include artificial intelligence and technology. Today, our participants will grapple with a profound, relevant, and increasing complex question: authorship in the age of AI. Should AI hold copyright? The teams competing in this round are TC05 arguing for the motion and TC04 arguing against the motion. The esteemed panel of judges is respectfully requested to deliberate and identify the best speaker for this round of the debate competition. Your articulation and persuasive arguments and insightful delivery will be greatly appreciated in acknowledging the outstanding talent among our participants. This debate will unfold under the following structure. Each team will be allowed 10 minutes to articulate their formats. The format is as follows. First, the opening arguments will be made by the team for the motion, followed by the opening arguments made by the team against the motion. Then, the rebuttal by the team for the motion, followed by the rebuttal made by the team against the motion. In the end, first the closing arguments made by the team for the motion, followed by the closing arguments made by the team against the motion. The teams are requested to strictly adhere to the time limit specified. We wish both the teams the very best for this round. Kindly wait till I set the timer and then we can begin.
I hope my screen is visible. I would like to explain the timer towards the left is for the team for the motion, and the timer towards the right is for the team against the motion. I would now like to ask the team for the motion to kindly proceed with their opening statements.
We are both created and create. Why cannot our own creations also create? A very good afternoon to the respected panel of educators, my worthy opposition, and our host Adhika, and all those who are present today. Your presence means a lot to us. I am the speaker one representing Team Code 5, joined by my marvelous co speaker, and together we stand firmly in favor of the motion. Yes, AI should hold the copyright. We are incredibly proud to propose this motion and thank the Honorable Panel for giving us this opportunity. What can you expect in this speech? Firstly, some top level framing to set the debate in motion, and then I'll walk you through two substantive arguments that support the proposition side of the House. So now let's not waste any time. Let's finally begin by challenging the narrow definition of authorship. Historically, the idea of an author was that a person who was able to hold pen. But now the time has changed. We have seen times like COVID 19, Ukraine war, space missions, Trump's reign, and whatnot. This technology has advanced, and it is this technology and AI I'm talking of. I would also like to cite here the landmark case of Sereny of US Supreme Court, where Justice Miller clarified authorship is not manual labor, it is the origination of expression. Let's fast forward it to today, and we have generative AI systems like ChatGPT, China's DeepSeek, Google's Gemini, What they're doing, they're not copying, they're not collaging, but combining billions of data points into new and unique forms. Isn't that authorship? The concern is very simple here. Why cannot our own creations also create? I would be lying here if I don't confess that I also use one of these AI software to check the grammar of my speech. And believe me, it did a satisfactory job. So let's confront the main elephant in the room, the human authorship requirement in Section 2 Clause D of the Indian Copyright Act. It was amended back in 1994, and this section defines an author based on the category of the work. For example, for literary works, it's the person who creates it. For photographs, it's the person who takes it. And for computer generated works, yes, that all category also exists. For computer generated works, it's the who causes that work to be created. So section 2D already contemplates computer generated works and assigns authorship to the person who caused it to happen. So yes, a framework is existing. We are not reinventing the wheel, but what we are doing is we are asking to acknowledge that the wheel now turns faster with AI as the co-driver. The law already allows for joint authorship. So couldn't this be the model for AI human collaboration? When a human engineers a prompt and AI executes the creative generation, their roles are interdependent and interwoven. The final work cannot be split. The joint authorship provides the perfect doctrinal bridge where humans remain involved, yet AI creates input. So, this approach prevents dishonest claims of sole human authorship. As I would like to cite here the Canada's very famous Sunset Serenity case, where a creator lied just to fit in this copyright protection framework. So, here we are incentivizing the dishonesty when we refuse to evolve our laws. So let us look this from the economy and numbers also, the very foundation of a country. Now imagine that you are building an AI generative system. You put a lot of inputs there, you spent a lot of time, you spent years on n number of days building that model. And when finally it comes to reap the actual benefits of the same, news, the law says that you can't get that copyright framework. So why would developers then keep innovating if their output has no legal protection? To be honest, if I am at that place where no protection is given to the work I do, then that's a waste of energy which reaps no benefits. So then why would a person do that? Here we are punishing innovation and discouraging the investment. Let us not remain the prisoners of outdated laws. Let's not ask if the author has blood and bones, but whether the work itself carries originality, intention, and creativity. It's high time we modernize our understanding of authorship, use joint authorship as a model for human AI collaboration, and promote honesty, transparency, and innovation. At the end, I would like to quote one of my role models, Sundar Pichai, the CEO of Google. The future of AI is not about replacing humans, it's rather about augmenting human capabilities. Thus, I, as Speaker 1 of Team Code 5, stand proud to propose this motion. AI must be recognized as an author, AI must be granted copyright because the future of creativity demands it. Thank you.
I would now like to request the DC04 to proceed with their opening statement.
Ma'am, I just had one query that I will be speaking for 2.5 minutes and my uh, counsel would be speaking for another 2 minutes. Is that fine?
Yes, the division of the time is upon your discretion.
Fine. Okay. Thank you, ma'am. We humans came to existence 3 lakh years ago, and honestly, for what learned operants are we different from any creatures existing on this world, be it an artificial creature or be it a biological creature? Mind, the unexplainable part of the brain, is something we have, Alan Turing had, McCarthy had when they were creating the artificial intelligence. I quote McCarthy when he said that AI is the science of making machines do things that require intelligence if done by human. So what is AI for? AI is merely for the purpose of assistance. It was for assistance, it is for assistance, and it will always remain for assistance. The origin of IPR goes back to the point of civilization called Cyprus in Greece, where 1 year patent were granted for newly culinary creations 500 BCE years ago. My learned opponents, they were granted for exclusive right over creation of minds. To make it more clear, till date, there exists no AI which has a conscious mind. Now coming to copyrights, 1710 was the first time Statute of Anne came into existence, giving a human author the power to protect their work. Until this date, the copyrights are beheld by the human beings themselves. My learned opponent quoted about Section 2D6 of copyright, which defines the author of a computer generated work, which means that the person who is generating the works to be created by the computer. So that means that the copyright is not being granted to the computer, not to the AI, certainly. And let's not forget, last April itself, the DPIIT committee, through its they formed the expert committee, has acknowledged that our current copyright law does not recognize AI generated content. If AI truly deserved copyright, there'd be no reason for DPIIT to form this expert committee. So the issue is, why should we give the rights to an entity which generates pictures, stories, codes, data, literature, each and everything from the data which is fed to it by the Homo sapiens content itself? Van Gogh's original painting was slapped onto an extra image to develop a new random image, and voila, Ankit Sani with some random AI, Raghav, titled it as Suryast. If copying and pasting with a digital brush now counts as creativity, maybe we should start giving copyright to photocopiers also. Is this copyright registration even deservable? Logically speaking, on top of that, I completely deny it and say that this is a this is directly an infringement itself. And if this particular Van Gogh image was not present in the public domain, this would have been a that copyright infringement. As the Bible reminds us, the potter has a power over the clay, and Buddhism teaches us that skillful means is not a fiction, but a way to comprehend truth through imagination and imagery. But let's not get carried away. It's still the potter, the human, who gives it the shape, and it's still the mind behind the image that gives it the meaning. Thank you. And now my speaker two will speak about.
Uh, to add on to what my co-counsel said, distinguished judges, esteemed opponents, and speaking against the motion, I will demonstrate why AI should not be granted copyright protection by assessing the essential requirements of what copyrights are. Firstly, my argument is related to the nature of AI. As said by my co-counsel, let's be clear about what generative AI is. These systems are sophisticated pattern recognition tools that process massive data sets of previously human created work. Through human intervention, prompts, and carefully curated datasets, AI reproduces patterns and creates content according to the provided instructions. Secondly, which brings me to my second point, but can AI truly create something on its own? As I said, every AI output is fundamentally derivative, making it a collaborative output from what humans feed into it to what it actually comes out upon. Building upon human creativity without the capacity for originality. AI does not understand what it creates, it merely produces statistical human expression. For example, the ongoing lawsuit on AI by where all over the world, which is stealing Studio Ghibli's art style along with the related environmental concerns. Thirdly, I would like to further my argument by citing a legal precedent of Davos by the creator Thaler and its surrounding jurisprudence. Davos, an AI system which was used to generate inventions on its own, the case spanned around 17 jurisdictions asking for granting AI recognition for the owner for recognizing AI as a creator. The Australian court unequivocally stated that being human isn't merely a presumption for granting copyright to an AI output, it is a fundamental requirement. This aligns with US's law, which requires a natural person for copyright ownership. This isn't an arbitrary distinction from distinguishing technology from a human. It reflects the core purpose of copyright law itself. Indian copyright law as well and patent law have no provisions for the act. My last argument for making the case is the purpose of why copyright law even exists. It was created to promote progress by incentivizing human creativity. It protects the economic interest of the creator. while ensuring society benefits from their work. AI cannot be incentivized. It feels no pride, no satisfaction, no economic, financial need. It cannot be motivated by copyright protection because it lacks consciousness or self interest. Granting copyright to AI would serve no policy purposes, and maybe that's why the Copyright Act still does not consider AI to be a part. I would like to conclude my submissions through this final point.
I would now like to request the team TC05 to commence with the rebuttal.
Greetings to the esteemed judges. With due respect to the arguments made by the opposing side, I'd like to address a few key points. While the opposition have raised some valid concerns, I believe this reasoning has certain flaws. AI, made for assistance, is not only limited to assistant only. In present time, it has evolved itself to work on its own, create stories, music, click pictures, even capable of making art. Main aim of copyright is originality, and where AI can ensure it, then it is entitled for that claim. Yes, Section 2D currently limits authorship to humans, but that's precisely our point. Laws must evolve. In Thailand versus Commissioner of Patents, the court acknowledged that the legal framework has not caught up with AI's capabilities and called for reform. We propose joint authorship, recognizing both the human creator and AI system. This does not erase human accountability, it strengthens it. The law has always adapted to technological change, and copyright now must do the same. We are not just asking for recognition of AI, we are demanding fairness, transparency, and a future ready legal system that protects all creators. It is true and undeniable fact that our current laws were not made keeping AI in mind. But this does not stop us from rethinking them. AI is not a natural person, but corporations, they are also not natural persons, but still hold copyrights all the time. The law is to evolve itself to recognize AI generated works with proper attribution, perhaps by the developer or the AI itself, under a sui generis right. About the contention of creativity, modern AI, like generative models, create unique outputs based on learning, copying. AI systems also create original works, things that were not explicitly told to create through learned data and patterns. It is not only limited to processing data, it has specialized itself in creating on its own. If AI can paint a portrait, write poetry, or compose music that even judges and publishers can't distinguish from human work, then how can we say that it is not creative? The law already recognizes corporate authorship, which also lacks the human element, emotions, and consciousness. Creativity stems from originality, not emotions. Every artist learns by studying past work. Musicians are inspired by older songs. Writers borrow themes from classic, yet we still consider their output original. AI too learns, but outputs are often novel, unique, and unpredictable. The standard is not absolute but originality. It's transformation, creativity, and novelty, and AI often meet these standards harming human creators. Same was said about photography, printing press, and digital art tools. Those were also criticized in earlier times because of the changing time. But instead of suppressing innovations, banning technology, we created rules and regulation which can coexist with human creativity to ensure balance. Perhaps by limiting the scope duration of AI copyrights. AI is not replacing human creativity, it's expanding the canvas. AI copyright is about economic rights and protecting innovation. We don't protect corporate works because CEO will be hurt or will suffer damage. We protect them to promote investment and fair use. Protecting AI created work incentivizes investment in AI development, ensuring progress in science, art, and innovation. At one point, it was also difficult to track film piracy or software copying, but we developed tools for the same. And now we need to develop these tools for AI too new attribution and tracking mechanisms, which will resolve many practical issues without denying rights entirely. We are not saying AI should replace human creativity, only that its contributions should not be erased. Let's protect creation where it comes from. And that's it from my side.
Thank you, TC05. I would now like to ask TC04 to proceed with their rebuttal.
Sure. First of all, TC01 speaker started by saying a statement which ended by saying, why not create our own creation? That is the point that we are arguing here, that artificial intelligence should not be getting copyrights, because it actually spoils the creativity that all the creators are actually having. From time of Mahabharata, from time of Bhagavad Gita, we have always seen that it is always about the mind, it is always about the consciousness, and the creativity lies in us. That is my first point to argue. Another thing is, TC05 speaker 2 had stated a point about corporations, as to why corporations have a copyright, and therefore artificial intelligence should also have it. If you actually remove the corporate wheel of a corporation, you will get to know that all of these copyrights are created by the people themselves and not otherwise. But in the case of artificial intelligence, when we are arguing about it, it is not created by the human beings. It is being created by an artificial intelligence, which is actually certainly a copied work. As I stated already in my opening argument about the art called Suryast, it was just a Van Gogh painting and some random image which was combined together, and it is directly a trademark, a copyright infringement, and not, we cannot actually categorize it. Some more questions that I'd like to put to PC05, my learned opponents, is first of all, AI, as you stated that AI deserves copyright. So tell me, which nationality should we assign it? Because Copyright Act of 1957, Section 7 talks about the nationality of the copyright owner. If we talk about AI right, why not are we talking about the liability? If it creates something infringing or harmful, say something seditious, something deepfakes, or maybe some revenge porn, who will be liable for it, the maker or the AI? Another thing that I'd like to put is, uh, you said about AI being able to create, but do you actually genuinely believe that copying pattern from multiple, humans have created multiple amount of content in this world, and they just copy it and they give you an answer for it? Do you actually think this work needs to be copyrightable? And can you name one AI generated work that was not entirely based on the already pre-existing human data that is present in the world right now? I rest my case here. Thank you.
If the judges allow,
TC05, do you have any rebuttals to be made against TC04?
yes,
Kindly
ma'am. If the
proceed.
judges allow, we would like to this. Yes, ma'am. Regarding the point raised for corporations, US law have in many cases the courts have said that in copyright the main requirement for owning copyright is the human element, that there should be consciousness, inheritance, and all those points. And in corporation, this is the main difference. They are recognized as juristic persons. They are not humans. They are not natural humans. And in copyright law, it is about natural humans. And corporations is recognized. That is why we say that AI should also be recognized. Regarding points of liability, nationality, then these are those practical problems which always come whenever we opt for something new. And these are to be tackled by legislation with time, that panels will be set down. Uh, Now I'll leave the rest to my.
Thank you so much. I continuing with the
I'm sorry to
questions that has
interrupt. TC05, you have run out of time. In case the judges permit, you can get extra time, so you may ask for the same.
3 minutes.
3 minutes.
yes. Thank you so much.
Thank you.
Thank you so much, respected panelists. Continuing with the questions that have been raised by our opponents. First, talking about one query that has been raised by the first speaker of the opponent, that the statement that I mentioned in the starting, that was we are both created and create. Why cannot our own creations also create? So I think there is a slight confusion. The statement I'm making here is why cannot our own creations also create? So I don't think any further clarifications need to be made for the same. Talking about the nationality of an AI generated work, the solution can be to assign the nationality of the AI creators to the AI creator or the party responsible for its development and operation. Till then, AI gains independent legal standing. The nationality of the AI generated work should reflect that of the developer or the country where the AI was substantially controlled or operated. And this will help us to come up with the possible solutions for the same. The point we are pointing out is that the legal evolutions and the changes to the legal frameworks are essential. And as a time change, we need to adopt to these changes. Another very important question that the opponent raised was that one work that is not taken from any other source, which is not AI generated. So there has been a case which they also mentioned, that was AI like Dell or Midjourney, based on a purely prompt with no direct replication or copying of existing images. So this I also mentioned the Sunset Serenity case. So there the Honorable Court of the Canada, uh, at the end they gave it the right to the actual AI generator artwork created by the Dell. This is one of the case I would like to hear mention. I hope that suffice the question raised by the worthy opponents.
TC04, if you have any counter arguments to be made, you may proceed.
I would like to counter the speaker's second's point that when they said that AI should be granted a juristic personality, copyright as a juristic personality does. I would like to counter that by saying no matter how advanced AI technology becomes, it fundamentally lacks the characteristics we associate with a legal personality. It is not the same as a human personality. Unlike corporations or other non human legal entities, AI cannot, for example, accept legal responsibility, enter into agreements, exercise, I guess, independent judgment, hold assets without human intermediaries. Thereby, I would like to argue that juristic personality would differ a lot from um, an artificial intelligence software. Um, Adding on to that, the question before us, we would like to clarify isn't whether AI can generate impressive outputs. It clearly can. The question is whether copyright law should be fundamentally transformed to accommodate machines without consciousness, creativity, or legal standing, where we know that the essential idea of AI is derivative, which is taking away from previously existing creators. It's not the same as being motivated by a creator's art. It's essentially stealing from a large database of pre-existing works and then creating a new thing out of it. I rest my case. Thank
Um, I would like to add that the counter that I received from TC05 speaker 2 and TC0 speaker 1, TC05 speaker 1, I could understand all your points, and I would like to say something about TC05 speaker 2. She talked about corporations, but it still does not change the fact that all the creations of copyright creations that are being created by the corporations are still being created by the human beings themselves, which is not still the case in the case of artificial intelligence. There is something called consciousness. If you go back to 16th century, you'll see that people, the artists, they did not want money for their work. They wanted recognition for their work. And that is why somewhere or the other, the laws for copyrights and IPR actually started being created because they wanted their work to be their own. But in this particular case, there is certainly no amount of consciousness that lies with the artificial intelligence. And therefore, there has to be no amount of IPR that needs to be granted to them. IPR rights that needs to be granted to them. Another thing is about nationality. As Speaker 2 was talking about, you know that when there is a change, the laws need to change. But certainly, the case of nationality, there has been no such development till now. Other than artificial intelligence has come, that we have needed to change the nationality itself. The major reason for Section 7 being added in this Copyright Act is because nationality is certainly a very big concern. If today some AI, creates some wrong image, then in that particular case, would you blame an Indian who has the maker who is creating it, or the person sitting in US, ChatGPT owner, OpenAI owner, who is the owner of the artificial intelligence? Will I blame them for that? So there is indeed a lot of complexity, and therefore there is no need for us to grant copyrights right to IPR, to artificial intelligence. I rest my case.
Uh, TC05, would you like to make any rebuttals or would you like to proceed with the closing statements?
I would just like to say that complexities exist But over time, we have to solve them. And with this, as we have paucity of time, therefore, we will like to proceed with the closing argument, as this is a debate which can go on for hours. But here we have to respect the judges and the platform. So, proceeding with the closing arguments, respected judges, esteemed panel, and all present, as I draw my arguments to close, I leave you with a simple yet powerful question. If creation, be it a painting, a poem, or a piece of music, can move us, inspire us, or make us think, does it really matter whether it was made by a human or an intelligent machine? Artificial intelligence today is not just following commands, it is creating, from breathtaking artworks to symphonies, from storytelling to design. AI is producing work that rivals human creativity. If the outcome is original, expressive, and valuable, then why must we deny it protection under copyright laws? Justice Gautam Patel in a lecture recently said, we are in a twilight zone where the law stands uncertain as technology races ahead. But twilight is not darkness, it's the beginning of change. And maybe this is our moment to reimagine how we define authorship and creativity. We already allow non-human entities like companies to hold rights. Then why not AI, which is actively generating content? Recognizing AI's role does not mean sidelining human creators. It means acknowledging the world we now live in, where human ideas and intelligent machines often work hand in hand. We have to integrate AI into our system. Let's not fear progress. Let's shape it with fairness, imagination, and vision. Thank you to the panel for your time and to my fellow speakers for such a thoughtful debate. It's been a true honor to argue today and present our stance concerning the copyright of artificial intelligence.
TC04, you may proceed with your closing arguments.
Um, um, Respecting the panel's time and reiterating on TCO4 and our reasons on why AI should never be granted copyright protection, I will be speeding up my submissions. Firstly, AI systems are derivative tools. They generate outputs by processing human created words, making them inherently incapable of true originality. Secondly, copyright exists to incentivize human innovation. AI cannot be motivated, reiterating my point, cannot feel pride, requires no economic protection that humans do, and the reason of why copyrights exist. Extending copyright to AI would only enrich technology companies while devaluing human creative expression that would die down um, by by the by companies. Finally, AI fundamentally lacks legal personality. Unlike corporations or other non-human entities, it cannot accept responsibility, enter into agreements, or act as an independent legal actor. I urge you to uphold the integrity of copyright law by recognizing it as an exclusive domain of human creators. I give the mic to my co-counsel.
Learned judges and my dear opponents, now I would like to ground our discussion to the fundamentals of the copyright law. Section 17 of the Copyright Act states the first owner is the author. Lovely, but who's the author here? Siri, ChatGPT, or maybe, Raghav the AI? Should we call him into the court? Now, suppose we do give copyright to AI. Next stop is liability. What do we sue? Who do we sue if there is infringement? The CPU or maybe Elon Musk's Tesla when it drives itself into a wall? Should we handcuff the car and send it to jail, or should we handcuff the AI and send it to jail? Honestly, if we give the machine the rights of humans, should we also give them the duties? And let's not forget the real tragedy, which is about the creativity. The moment we equate the neural network remix with the human imagination, we lose something irreplaceable. That is the creativity that we human beings possess. I rest my case here. Thank you so much, learned judges and my dear opponents, for listening out to our points.
I would like to thank both the teams for their compelling arguments. Now, I would like to request the judges to proceed with any feedback that may have for the teams. Ms. Kalyani, would you like to go ahead first?
Yes, good evening, everybody. And honestly, it's such a pleasure to be here. And thank you, organization team, for inviting me here. And really, I'm impressed by all of your insights and thoughts, and to see such a creative minds here. Am I audible? Yeah. Okay. So, feedback as in their, yeah, the confidence level was great, all of you. And also the evidences, the case laws. Also, you have mentioned about the fair use and joint authorship. It was I was not expecting, but you have mentioned all of that. So, yeah, I am happy to see that you have mentioned all these things. And yes, yeah, that was great, all of you.
Thank you, ma'am. I would now like to ask Ms. Aishwarya to go ahead with her feedback.
Okay. Am I audible? Okay, fine. So I think I have the same opinion like Kalyani ma'am said. Uh, you know, various different opinions like within a short time period. Like we are very honored to like to hear from you. Like different opinions, and it's kind of a strong opinions. When you hear what TC5 is saying, we can it's true. Okay, and when it's when the roll is it's rolling into TC4, yeah, that is again true. So that is, I think, the kind of topic that we are dealing with, right? Because artificial intelligence, kind of, everyone is okay. So if you ask this question to somebody, artificial intelligence, what it is. So everybody, yeah, I'm using it for my assignment works, SEDA works. But when it comes to copyright and all, like pretty much everyone is little much confused. Like how far we can use it, and like, can I take a stand? Like whether it's four, am I supposed to go with for, or like, is it supposed to be against it? So that is the kind of like the topic that we are dealing with today. AI in like the authorship and AI. So I think the point I personally feel is that the thing is that the boundary, we can call it as a boundary or kind of the intersection, like the regulation, how far we can regulate it uh, by identifying the boundary, because that is very problematic, and still the professionals and everyone is vague on that point. So where we can fix the boundary, definitely we need an act, and we need something to protect and regulate our works and copyright. And I think nobody will go completely against AI. Those who are speaking completely against, against AI, artificial intelligence, still we know we need that, but we cannot completely deny the role of artificial intelligence in our works, in our the work we are creating, the assignments we are writing. Definitely, it's kind of within short span of time, you're getting the entire details of a particular topic. How can somebody be against it? Just imagine, nobody can do it. But still, how far we can ensure the authenticity of that? Like what to say is that authenticity of authorship. It's not just authorship, the authenticity of authorship. I think that is something more concerning about when we are dealing with AI in authorship. Like apart from the traditional authorship, like which is associated with a human being, the rest is something which is associated with a machine. But the irony is that it's something the machine is again created by a man. It's kind of set of algorithms, it's work on kind of set of programs, and just like replicating or stimulating human intelligence. So we know that we cannot trust a single machine for research. We can use this artificial tool, but we cannot use the same for any other purposes, which means it is again biased like a human being. Like if we have our own opinions for various topics, the same is applicable to AI tools as well. You cannot use the same tool for all your purposes, right? So that is the biases is there. So the thing is that we cannot be completely trust AI or completely deny AI or its role in when we talk about the authorship or the copyright. We cannot take ultimately a stern stand. Yes, I'm for it. I'm completely against it. The thing is that though you are speaking against it, reality we are standing in between that. In between that, right? And we are very confused about the intersection and the in determining the boundary. So starting with, I think, TC5, What I personally feel is that, the first speaker, she was very confident. She know what she's saying. So as a judge, we can point it down. What her point is very clear. We can note it down. Okay, this is she saying. Okay, okay. Then like you said about the originality of origin. It's not about manual, or it's not something which is associated with human beings. Completely about the originality of origins. Like what if it's not a problem. Okay, it's something which is machine oriented or something which is produced by the machine itself. But we are giving the copyright to the origin. I mean the work itself, not so that's how you are saying, or you are ultimately supporting AI or the copyright of AI. Not because we don't need to associate with a human perspective or something which is a creative work of a human being, right? So that is what that was the thread that you was talking about in the your opening argument. Your entire argument was, you know, based on that particular point. That was, I think, that's what I get from that opening argument. Then you talk about joint authorship, and I think the closing argument, I think the second speaker, yeah, she's actually talking about it's not only assistance. We cannot overrate artificial intelligence. I mean, but she's also saying it's not something which is assisting. So where is it? Kind of, as as I said earlier, it's clearly middle of it. Then so this is basically about TC5. I think the presentation wise and the content is again good. You actually mentioned some case laws and all. It's good. And the point is that the difficulty is that we cannot spoke completely for it, the topic. But still, I think you people have done a nice research and try to give your best. Okay. So congratulations. So that's all about TC5. Who spoke 4, and I need to, okay, that is in T04, who actually spoke against the motion, right? So here, I think the first speaker, TC4, a first speaker, she's very spontaneous. I think the other judges can also, maybe they also noted the same. She's very spontaneous when it comes to rebuttals, and right, she was very spontaneous in with her arguments and all, and and they are and they clearly said that it is just assistance only. When we talk about AI, they are clearly saying it's only about the assistance, and saying that no conscious mind. That is something which is, you know, differentiating us from the rest of the creation. Like we have the conscious mind. We know what we are doing, and the kind of some other. It's not a sense, but still it's debatable. A mind is there. Where is your mind situating, and the powers of your subconscious mind and all. That's again another branch of study. But still, that is something which is, she said, that is no conscious mind. So we cannot connect or attach authorship to a AI generated work or AI generated product. I mean work. Then yeah, that's all about it. AI cannot be given ownership. Then the second speaker, she was also good. She was also mentioning a few case laws supporting her side. Right. So the thing is that basically, it's very easy to spoke against the motion, right? That's the nature of this debate. It's very easy to spoke against the topic, and it's very difficult to speak like the four, because we know the thing. We all are our opinions, and the topic we all are in the middle. So I think both the teams have done your best, and yeah, speaker one, speaker two of both teams, you have done a great job. I love the way you present your content very confidently, and it's very audible. We get what you're saying. The cases you try to add few cases. I think there are a lot of cases are there, but it's okay. You try to mention few of the cases. Okay. Then AI Act is there. I think you could have mentioned it and how it is, but it's okay. Still, you have done a great job. I think I'm not wasting much time. I think Divya ma'am is there. She will continue the rest of the judgment. Okay, so congratulations to both the team. Hope we can see you in the next round. I mean, the finals. All the very best. Thank you.
Thank you, Shwara ma'am. I would now like to ask Divya ma'am to give her feedback to the teams.
Yeah, so firstly, thank you, Team UPLRC, for giving us this opportunity for judging young minds who are literally putting their efforts. They have put their great efforts and the preparation, I can see. And it was absolute pleasure to witness such thought-provoking debate competition, the semifinals. And the topic was really thought provoking, and the preparation you people have done was legit, I can say, because it was like Aishwarya ma'am said, it was in the balance. We do not know where to stand, and yet you try to prepare yourselves. So I like the way the opposing team, TC04, like powerfully they reminded us about the authorship. That is not merely about output, but about the intent, accountability, and about the human originality. So the point they were carrying, I like that. And also about T.
Ma'am, am I audible? Ma'am, actually, yes, ma'am, I think there was some connection issue in the middle, so we could not hear you.
Yeah. Okay, so I turn off my camera. I think there's a network issue from my end. Okay. Yeah, so I was continuing as team TC5. I had like the compelling arguments that the evolving nature of creativity and how AI's role in generating content is necessity for the legal recognition. So I like the both the teams' efforts and how the discussion was the very point of how law, ethics, and technology are intersecting each other. So finally, I can conclude that what stands out today is not just the question of who owns the content in digital age, but how our legal and moral system must adapt without compromising on fundamental principles. So it was incredibly proud moment for me to judge this debate competition and how these young minds have put in their efforts. So I would just finally say that keep questioning, keep learning, and continue to engage with the world through the power of informed discourse. That's it. Thank you.
Thank you, ma'am. The UPLRC extends its heartfelt gratitude to esteemed judges, Advocate Kalyani, Advocate Divya, and Advocate Ashwarya for their generous contribution of time, unparalleled expertise, and insightful perspectives to this intellectually stimulating semi-final round. Their disconcerting observations and constructive assessments not only enriched the quality of the debate, but also served as a guiding light for all participants, encouraging deeper inquiry and reflection on a subject of growing global relevance. With profound gratitude, we extend a special note of thanks to our esteemed National President, Vaishnavi Ma'am, and for her visionary leadership. We also deeply appreciate the tireless dedication of Prashansa Ma'am, a National Council member and UPLRC mentor, and Khushi, our esteemed State Vice President. Our sincere thanks also to Kashish, a valuable council member, and all the other committed members of UPLRC Council. Their efforts in conceptualizing and executing this event have been truly instrumental in making it a meaningful and impactful experience. We also take this opportunity to celebrate the commendable performance of all the participating teams. Their meticulous research, eloquent presentations, and dynamic engagements with the theme reflected not only their academic rigor, but also their readiness to tackle the evolving challenges of the legal world. The clarity with which they navigated complex questions at the intersection of technology, creativity, and law was truly inspiring. We believe this debate has sparkled important conversations around the future of intellectual property in an AI driven era, and we are confident that such platforms will continue to shape through leaders and change makers of tomorrow. As we conclude this round, we look forward to witnessing the continued excellence of these brilliant minds in the grand finale and beyond. Thank you. I would now like to request all the participants to kindly leave the meeting.